There you have it, folks. Lady Justice is flatlining on the operating table, and the future of the rule of law in this country is in serious doubt. She had a good run. Donald Trump's DOJ just brought absurd criminal charges against former FBI Director James Comey as revenge for Comey investigating ties between the 2016 Trump campaign and the Russian government. Trump's motivations are not mere speculation. We know this because former U.S. Attorney Eric Siebert in the Eastern District of Virginia chose to resign rather than invent crimes and participate in brazen open corruption. And so, Trump replaced him with an unqualified hack who's never prosecuted a criminal case and isn't even licensed to practice law in Virginia. And Comey won't be the last victim of Trump's corrupted DOJ. He's got a hit list. He's admitted this in public. It's like if Richard Nixon tweeted out the White House tapes instead of erasing them. So let's go over what the court documents against Comey actually say, how we know the charges are bull, and how they point to a broader strategy to destroy the rule of law in 3 easy steps. So, suppose you're an authoritarian who wants to get rid of the pesky rule of law in a democracy. Well, your best bet is to abuse the justice system until you end up with the rule by law, not rule of law. As Scout Owl covered in his deep dive of the satirical video game Helldivers 2, the critical difference is that rule by law systems try to maintain the appearance of legal norms, even though lawlessness has run amok. So there are courts, judges, adversarial counsel, and a semblance of due process, but the outcomes of a rule by law system are actually foregone conclusions that serve the desires of autocrats in power. For criminal justice in a rule by law system, this means that enemies of the autocrat are first deemed guilty, and then the justice system works backwards to figure out a crime. Any crime, really. It's a sweet gig for lawyers without talent or ethics because your cases are won for you. But this is easier said than done. It requires attorneys and judges who swore an oath to uphold the rule of law to willingly participate in open corruption. And that's exactly what happened in Virginia. Over the past few weeks, the Eastern District of Virginia, or EDVA as it's called, has been at the center of an internal struggle that has been raging within the Justice Department. Trump wants his enemies criminally prosecuted, even if there's insufficient evidence. The district used to be run by Eric Siebert, a guy with widespread Republican backing and more than a decade of experience as a criminal prosecutor. But Siebert was forced out on September 19th, reportedly after he questioned the viability of bringing prosecutions against Trump's personal political targets. The next day, on Saturday, September 20th, Trump took to Truth Social to address his attorney general. Pam, what about Comey, Adam Shifty Shift, Letitia? Justice must be served now. Trump then appointed Lindsay Halligan as Siebert's interim replacement with explicit instructions to pursue charges against his political opponents. Halligan is an insurance lawyer with virtually no prior experience as a prosecutor. Halligan's primary experience with federal litigation was the civil suit she filed on Trump's behalf against the government for searching Mar-a-Lago for all the stolen classified documents he refused to return. It did not go well. In August of 2022, Trump appointee Judge Cannon rejected 2 filings Halligan submitted because they didn't comply with local procedures. And yeah, all lawyers make mistakes, but this just underscores how bad Halligan really is at her job. And now she's the top prosecutor in the Eastern District of Virginia, and she just filed charges against James Comey for crimes. To be sure, Trump's fixation with Comey isn't new. In 2016, the FBI investigated Russian interference with the US election, and they uncovered direct links between Russian assets and Trump campaign operatives. And so, for years, Trump railed against Comey and opined that he should be criminally charged. But Trump never articulated a plausible legal theory, or really any legal theory, as to how Comey's conduct during the Russia investigation could even possibly amount to a criminal offense. He's convinced Comey is guilty of something, and he wants the Justice Department to figure out what. That is rule by law. And look, let's address the 6'8" elephant in the room. There's a lot of people on both the left and the right who don't exactly like James Comey. But in this country, we don't prosecute people just because we don't like them. To do so is a gross perversion of prosecutorial power. Normally, you start with a crime and then figure out who done it, rather than starting with a person and then deciding what the done. But that's exactly what happened here. And in figuring out what the done, Trump faced a ticking clock. The root of his grievance, the Russia investigation, happened nearly a decade ago, so most of that stuff is already outside the statute of limitations. That left Trump with essentially one option: Comey's September 30th, 2020 testimony before the Senate Judiciary Committee. That's the last testimony he gave, so I don't know, let's just say that he lied to Congress or something. Crucially, this testimony happened exactly 5 years ago, meaning that Siebert was forced out of EDVA just a few days shy of when the 5-year statute of limitations was set to expire on September 30th. And that's how we got Lindsay Halligan as America's top federal prosecutor for EDVA. But there's one crucial step that prevents the federal government from just charging whomever it wants with whatever crime it imagines. Halligan had to convince a grand jury that there's a there there. Now, if you're just as disturbed as we are about the government criminally investigating whomever it wants for no reason, you're probably going to want to take some action and shore up your online privacy. That's because data brokers vacuum up your personal info from all corners of the internet and sell it to anyone who wants to buy it. But you can fight back and take control of your personal data by signing up for today's sponsor, Incogni. Incogni removes your personal data from online brokers by searching the internet, reaching out directly on your behalf, and forcing them to remove your private information. If these data brokers resist, Incogni will take care of that too, because Incogni fights back. These data brokers are the reason why in the United States you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking because of how easy it is to find all this information online. It also might be why you're getting so many spam calls lately or even had your identity stolen. I've been using Incogni for a while now. In that time, you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me. So thank you to Incogni for saving me weeks of work and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it and publish it again. So if online privacy is important to you, give Incogni a try. Scan the code on screen or click down below to get a 60% off discount. And you can even try Incogni risk-free for 30 days. At the end of your free trial, if you're not into it, you can still get the exclusive 60% off discount later by using the code LegalEagle, all one word, at checkout. So sign up for Incogni or I'll see you in court. Halligan was sworn in as the interim U.S. Attorney for the Eastern District of Virginia on Monday, September 20th. Immediately after she arrived, the career prosecutors in the district, you know, the people who kind of know what they're doing, presented her with a welcome gift of sorts, a detailed declination memo, meaning a document that sets out all the reasons why, in the prosecutor's view, no charges were warranted. According to reporting by ABC News, the memo found that probable cause does not exist to secure an indictment, let alone a conviction at trial, of James Comey. Now, at this point, any ethical prosecutor would see the writing on the wall and hightail it in the opposite direction from the grand jury room. Federal prosecution standards are explicit on this. A prosecutor can only bring a case if 1, they believe the person will most likely be found guilty beyond a reasonable doubt, and 2, the conviction will most likely be upheld on appeal. Or consider bar ethics rules. Rule 3.8 of the American Bar Association's Model Rules of Professional Conduct says that the prosecutor in a criminal case, quote, shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. But Lindsay Halligan can't be swayed by ethical rules, apparently. Maybe she considers them improper ideology, like those communist pandas at the Smithsonian Zoo. With time running out, Halligan personally presented evidence before a grand jury in Alexandria, Virginia. That itself is really weird. The district's top prosecutor typically leaves grand jury presentations to her underlings, you know, the line prosecutors who work the case. And remember, Halligan doesn't have any prosecutorial experience whatsoever. Still, later that evening on Thursday, September 26th, the grand jury agreed to indict Comey on 2 felony counts for false statements and obstruction of justice. The grand jury also rejected a 3rd count, which alleged that Comey made additional false statements when he told Congress in 2020 that he couldn't recall receiving an intelligence lead related to the Russia investigation from 4 years earlier. Trump, for his part, was exuberant. Justice in America, he celebrated on Truth Social after news of the indictment broke. But that exuberance might be short-lived. Now that the indictment is public, it's become increasingly clear why career prosecutors won't touch the Comey case with a 10-foot pole. It's an embarrassment that never should have been brought in the first place. Now, you might be thinking, hey, a grand jury approved this indictment. Surely there's got to be a there, right? Grand jury indictments are ridiculously easy to get. In federal grand jury practice, the defendant usually doesn't get a chance to present evidence or witnesses or tell their side of the story at all. The rules of evidence don't apply, so you can introduce things like hearsay. And the standard of proof isn't beyond reasonable doubt. It's probable cause, which is an exceedingly low bar. All of which is why people say that any good prosecutor can get a grand jury to indict a ham sandwich. And Halligan only barely managed to get an indictment on counts 1 and 2. To secure an indictment, the rule is that at least 12 grand jurors out of 23 need to vote in favor. According to the court transcript, only 14 of a possible 23 grand jurors agreed to indict on the 2 counts. That means that at least some of the grand jurors refused to indict Comey. If my math is mathing here, this doesn't bode well for Halligan's prospects at trial. During a trial, 12 jurors must be unanimous on the verdict, and the standard of proof for guilt is beyond reasonable doubt. So what does the prosecution have to prove against Comey? Let's take a look at the charges. The indictment handed up against Comey on Thursday is maddeningly brief. It consists of just 2 passages. Blink, and you're gonna miss them. Here's what little we do learn from the indictment, though. The first count alleges that Comey, quote, knowingly and willfully made false statements to Congress in violation of 18 U.S.C. section 1001A2. The second count accuses Comey of obstructing that same congressional proceeding by, quote, making false and misleading statements in violation of 18 U.S.C. 1505. Here's the legal theory that they're basing these accusations on. In 2017, Comey was summoned to testify before the Senate Judiciary Committee. There, he was asked by Senator Chuck Grassley if he had ever authorized someone at the FBI to anonymously leak information to the media about the FBI's investigations of Donald Trump or Hillary Clinton.
Director Comey, have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation?
Never.
Question 2 on relatively related. Have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton investigation?
No.
Comey's response is a very clear no. But then, in 2020, Comey was summoned to testify before the Senate Judiciary Committee again. During that testimony, Senator Ted Cruz referred to the earlier exchange with Senator Grassley.
And Mr. McCabe, if he says contrary, is not telling the truth. Is that correct?
Again, I'm not going to characterize Andy's testimony, but mine is the same today.
Now, we'll talk about the McCabe thing in a bit, but both of the criminal charges appear to relate to this exchange Comey had with Cruz in 2020. The indictment alleges that Comey stated that he had not authorized someone else at the FBI to be an anonymous source for the media in regards to an FBI investigation concerning Hillary Clinton. The indictment goes on to allege that this was a lie. Allegedly, Comey knew that he had, in fact, authorized someone else at the FBI, identified as the mysterious person 3, to serve as an anonymous source in news reports regarding the Clinton investigation. Now, buckle up, because this is where things start to get really stupid. The indictment quotes Comey as falsely stating that he had not, quote, authorized someone else at the FBI to be an anonymous source in news reports, but that quote is actually not from Comey's 2020 testimony. It's from the exchange that Comey had with Senator Chuck Grassley in 2017.
Have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton investigation?
Now, remember, the statute of limitations for the 2017 testimony is up. But that exchange with Grassley was brought up again by Senator Ted Cruz during Comey's 2020 testimony.
Have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton administration?
So let's TLDR this already frustrating indictment. Cruz told Comey, "I don't believe you were telling the truth in 2017. Comey responded, "I stand by my statements." Good job, United States Justice Department. You got him. From a legal standpoint, this is just really stupid. Because to prove the charges, the prosecution needs to show that Comey knowingly and willfully lied when he said that he believed his previous statements to be true. Even if Halligan can lawyer jujitsu her way into basing the indictment on Comey's 2017 testimony, she still has to prove beyond a reasonable doubt that Comey told person 3, "Psst, hey buddy, send this shit to the New York Times, but don't tell anybody about it." So who was person 3 at the FBI? There are only a few possibilities, and none of them make much sense in terms of establishing a criminal case against James Comey. In fact, they're all astonishingly weak. The first option relates to a media disclosure involving Andy McCabe, who back in 2016 served as the deputy director of the FBI under Comey. The McCabe matter centers on an October 30th, 2016 article published in the Wall Street Journal, which cited an anonymous source confirming the existence of an FBI investigation into the Clinton Foundation. There was this whole internal investigation about it, and in a report made public in 2018, the Justice Department Inspector General found that McCabe, not Comey, had authorized two of his aides to speak with a Wall Street Journal reporter for the Clinton Foundation story. So to be clear, McCabe doing this was totally legal. At the time, FBI policy allowed both the director and the deputy director of the FBI to authorize that kind of media disclosure. But neither McCabe nor Comey have ever suggested that Comey knew about it or authorized the leak prior to the article's publication. In fact, it's quite the opposite. Comey has consistently denied authorizing the leak, and he has claimed that he was ignorant of McCabe's own plan to do so. And McCabe, for his part, has said that he and Comey didn't discuss the disclosure in advance of the article's publication.
I'm not aware of Jim Comey ever authorizing some other person to leak information. That's not something I experienced personally. It's not something I saw in all the time I spent working around Jim Comey.
Where McCabe and Comey's recollections diverge is with respect to what happened one day after the Wall Street Journal published. McCabe claims that he told Comey that he, meaning McCabe, authorized the leak. Comey says, no, McCabe didn't tell me about it. The Inspector General found that the overwhelming weight of the evidence supported Comey's version of the conversation. In other words, there's no evidence to suggest that Comey knew about or authorized the media disclosure in advance. At best, McCabe's account of the meeting might suggest that Comey acquiesced or ratified the disclosure after the fact, or something like that. But he never authorized it, even under the least generous version of the facts. And anyway, the Inspector General found Comey's side of the story to be more credible than McCabe's. There's another problem. Presumably, any prosecution predicated on the McCabe matter would kind of need McCabe, but McCabe would make a really awkward star witness. During Trump's first term, the DOJ already tried and failed to prosecute him for statements he made during that leak investigation. A grand jury in 2019 refused to return an indictment on the subject. It would be pretty rich, having sought and failed to charge one party to a memory dispute, to then turn around and try to charge the other. It just doesn't make any sense. And investigators apparently never even tried to re-interview McCabe ahead of Comey's indictment. Here's what McCabe told CNN last weekend.
I've not been contacted. I haven't been interviewed. They're not asked to interview me.
And look, I'm not the only one who thinks this McCabe theory is really dumb. Even Fox News contributors have doubts.
I love Ted, but McCabe never said that Comey authorized it. What McCabe said was that McCabe authorized it. This is a leak to the Wall Street Journal. And then he told Comey about it later. The only way that you could convict Comey beyond a reasonable doubt is Comey would have to truly believe that he personally had authorized the leak. He would have to actually have authorized the leak, and then he would have had to know that he was lying when he denied it to the Senate. They're not even going to be able to prove that he authorized the leak because, by all accounts, he didn't. So I don't think this case even gets to trial.
So the McCabe theory of the case appears to be a complete non-starter. But there is another possibility. The Dan Richman option. Richman is a law professor and close friend of Comey's who did some informal media outreach work on Comey's behalf and consulted for him on a few unrelated matters. Richman is not an FBI employee, but he did serve as a special government employee at the FBI in a kind of advisory role during part of Comey's tenure as director from June of 2015 to February of 2017. Richman's role as an informal media liaison for Comey came up in a separate leak investigation known as Arctic Haze. Now, this all became relevant because in 2017, the FBI launched an internal investigation into 4 stories that were leaked to the media. That investigation was codenamed Arctic Haze. Richman's relationship with Comey was a key focus of this investigation. And as of this recording, multiple news outlets are reporting that sources familiar believe the Comey indictment has something to do with Arctic Haze. The Arctic Haze investigation found that Richman certainly talked to the press on Comey's behalf, but it never found that Comey had asked him or authorized him to be a source for the story, much less to do so anonymously. To the contrary, Richmond was often quoted by name in media stories about the FBI and Comey. And look at the words in the declassified Arctic Haze documents. Those documents contain such sentences as, Richmond claimed Comey never asked him to talk to the media. The investigation has not yielded sufficient evidence to criminally charge any person, including Comey or Richmond, with making false statements or with the substantive offenses under investigation. And investigative efforts have failed to identify the sources or sources of the unauthorized public disclosure. Doesn't really sound like there's a there. And there's another reason to think that person 3 is Richmond. Richmond actually had a recent interview with prosecutors prior to the Comey indictment. Here's the thing, though. That interview reportedly didn't go very well for the prosecution. Reporting on the interview, the New York Times writes, Mr. Richmond's statements to prosecutors were not helpful in their efforts to build a case against Mr. Comey, according to 2 people familiar with the matter. So it seems like Richmond is person 3, but if so, the whole legal theory, like the case itself, is a total loser. But Comey got the message Trump was sending, and now it was time to fight like hell. Hours after news of his indictment broke, Comey responded with a short video uploaded to social media.
My heart is broken for the Department of Justice, but I have great confidence in the federal judicial system, and I'm innocent. So let's have a trial.
Now that Comey himself has responded to the public, it raises a critical question. How is his legal team going to respond in court? One obvious option would be to file a motion to dismiss based on vindictive prosecution. And look, such motions are really difficult to win. It essentially requires a showing that the prosecution retaliated against the defendant for exercising a legal right. Trump, in his federal election interference case in Washington, D.C., filed one of these vindictive prosecution motions before Judge Tanya Chutkan. He alleged that special counsel Jack Smith and President Joe Biden were prosecuting him in retaliation for his criticism of the 2020 election. Chutkan rightly denied that motion, much of which was based on a New York Times report in which President Biden privately expressed to his inner circle that he believed Trump was a threat to democracy and should be prosecuted. Trump also cited Biden's private remarks in which he wished that Attorney General Merrick Garland would act less like a ponderous judge and more like a prosecutor who is willing to take decisive action. Todd Blanche, who is Trump's criminal defense attorney and who is now the number 2 official at the Justice Department, is the guy who filed that vindictive prosecution motion on behalf of Trump. By contrast, Comey's vindictive prosecution motion would almost certainly be among the most compelling ever filed in an American courtroom. Even the public record alone makes a strong case. There's the years of taunts Trump hurled at Comey, the president's open calls for his indictment, his firing of the prosecutor who declined to pursue charges, his installation of Halligan as a replacement, the leaks outlining her intent and knowledge of the declination memo, the president's jubilant social media posts celebrating the indictment. You get the point. There's dozens and dozens and dozens of public statements that show Trump's animus against Comey. The discovery process tied to a vindictive prosecution motion would further expose the deeply corrupt and abusive path that led to the Comey indictment at the Justice Department. And given that juries can be unpredictable, Comey's lawyers may well view the filing of a motion to dismiss to be the less risky path. But Comey hinted at another option in his video on Thursday. As he stated, "I'm innocent, so let's have a trial." Comey, clearly confident in his innocence, isn't inclined to delay. And a motion to dismiss for vindictive prosecution doesn't address the fundamental weakness of the evidence itself. It doesn't, in other words, allow Comey the opportunity to prove his innocence before a jury of his peers. So yeah, Comey might push for a speedy trial, aiming to lay bare in court just how hollow the charges against him truly are. As Comey himself said,
"Fear is the tool of a tyrant."
James Comey is the headline today, and people on both sides of the aisle have grudges against him. But this isn't really about Comey. It's about the collapse of the basic principle that the law should apply the same way to everyone, no matter how powerful. When prosecutors resign rather than participate, and the president fills their chairs with loyalists who see criminal law as just another political weapon, it's not just Comey who's in danger. It's all of us. Trump has already said that there will be more enemies to investigate, more indictments to manufacture, more careers to ruin. If he can do this to the former FBI director, he can do it to anyone who crosses him. And once that line is crossed, it doesn't snap back easily. So yeah, this isn't about whether you like James Comey or hate him. It's about whether we still believe in the preciousness of the rule of law, not by law. Because the Trump administration clearly has a recipe to mutate the justice system into rule by law that serves his whims, and it's working. Step 1, purge the ranks of the Justice Department of all who abide by the Code of Legal Ethics. Step 2, install unqualified hacks, zealots, and loyalists who religiously obey your orders. Step 3, use prosecution as persecution against all your political enemies. Trump doesn't need to win a trial against James Comey to achieve the rule by law system that serves him. His DOJ will most likely fail in court against James Comey, but it honestly doesn't matter because the message here is clear. Offend Trump for any reason, and you will face the wrath of a fully weaponized perversion of the justice system.
Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel: transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.